I want to introduce, we have some people who have not been earlier to these lectures of exploitation of IPRs. Today we have a visitor, Peter Miller from San Francisco, and he's working for Schox Patent Group, which is one of the famous patent offices in California, helping especially startups and small companies with their patent portfolios. And it's not only about applying the patents, but also helping the small companies thinking about funding and how to arrange these funding rounds. Peter Miller is here because of the cooperation between Aalto Ventures program and Stanford Technology Ventures program. Jeffrey Schox, his boss, visited Finland last fall, and since then we have been exchanging ideas, and today you are talking about startups and patents. Before you go into your lecture, maybe you give a couple of words about your own background.
Oh, absolutely.
Okay, please.
Morning.
Morning.
I'm Peter. I work for, as Timo said, for Jeff Schox. Jeff started a firm about 10 years ago specializing only in startups. So aside from one company I'll talk about later, every one of our current 100 clients is a startup. They're actively pursuing their technology. They're raising seed money from angels or VC money from VCs. And they're all hiring their first engineer or their second engineer. It's we're in a sort of a niche market, and being in San Francisco, where our office is located, we're poised to work with so many startups in that area. The team is very small. Our firm is small. We have 4 patent agents, and Jeff, who's the 1 patent attorney. So I'm a patent agent. I've been a patent agent for about a year and a half. In the United States, the United States Patent and Trademark Office, the USPTO, issues its own bar exam. So I have a background in mechanical engineering, and I took this test that the Patent Office provides, and I am legally barred in front of the Patent Office. So I can prosecute patents, I can capture an idea, put it down on paper, file it with the Patent Office, and prosecute it until that document becomes an issued patent. So as far as my background goes, I used to be a mechanical engineer. I guess you never stop being a mechanical engineer in a sense, but I have an undergraduate degree and a master's degree in mechanical engineering from Stanford. While I was in grad school, I helped manage a manufacturing and design course of about 170 students a year, and I worked in what's called the Product Realization Lab. It's a large prototyping and machining facility. It's used by about, at the time it was about 800 students a year, and now it's grown to about 1,100 students a year. I studied manufacturing and robotics. Those are my backgrounds in a sense. Worked at a large like Fortune 50 company. In one division of that company, I designed klystrons. They're large power amplifiers used in linear accelerators to accelerate particles. And on the other end, I've worked at a startup making small, inexpensive consumer electronic devices. So I've been on somewhat both ends of the spectrum. And when I started working for Jeff, I did predominantly consumer products. That was what I had just come from. And but I've expanded that into pure hardware plays, pure software plays, software platforms, and also some medical devices. So I've been working for Jeff for about 2 years, and in that time I've written about 80, maybe 90 patent applications for about 30 clients whom I manage personally. These are clients that have, it's 2 co-founders trying to raise their first $100,000 in seed money. I've written patent applications for clients who have just closed $6 million in Series A funding. I've gotten patents issued for some of those companies. And one of my clients last year was actually acquired by Facebook. And we had written several provisional patent applications for this client of ours. And after being acquired, Facebook asked us to stay on and do additional work for them. So I've written about a dozen patent applications for Facebook, which is a multi-billion-dollar publicly traded company, moving out of that startup phase 7, 8 years later. So as far as IP goes, I've sort of seen both sides of tiny companies, big companies, and how they build and manage their patent portfolios. So I think we should probably address the elephant in the room, and that is, why are patents actually relevant to startups? We hear these reasons quite a bit, even from other attorneys, from VCs, from angels, from startups and co-founders, what they read online. Let's actually address each one of these. So are patents actually useful to enforce against a competitor? Are you actually going to sue one of your competitors for patent infringement? And as a big company, if you're Apple, probably. But if you're a startup trying to raise $100,000 in seed money, you're probably not going to take all of that money and sue somebody. It takes 4 to 6 years and $3 to $5 million to sue someone for patent infringement. It's a lot of time, it's a lot of money, and you'd be better off spending all of that actually developing a product. So if you want to scare your potential investors away, tell them that that $100,000, that $1 million check that you want them to write for you is going to go all to patent infringement lawsuits. They see very little potential for return in that investment. You don't actually know how the judge is going to rule 6 years later. You don't know if that judge is going to award you damages. You don't know if you'll still be around in 6 years, that you can actually afford to sustain yourself by spending all your money on litigation. It's a very risky endeavor, and you would be better off spending that time developing your product, proving that there's a market, building your team. Investors know that, they understand that. They don't want you to be involved in any kind of litigation whatsoever. Now, how about preventing someone else from patenting your technology? Patents are expensive. It's not just a one-time fixed cost of a couple $1,000s. It's years to get a patent, and it could cost you anywhere from $15,000 to $50,000. But just filing that patent application, paying an attorney to write and file this thing is 15 grand on average, at least in the States. And there are better ways to prevent someone from getting a patent on your technology. All that you need to do is publicly disclose your invention. Take 10 bucks, go buy a URL, write some blog posts about your technology to explain how to make it, how to use it. That's enough to bar someone else from in the future coming around and patenting this technology. If you want to take a slightly more professional route, write a journal article. Get it published in a well-respected journal, and send a copy of it to the patent office so they know about this invention that you had, so they can use it to stop someone else from getting an invention, or from patenting an invention. And so this also is not a particularly good way or effective or inexpensive way to prevent someone else from getting a patent on your invention. How about to generate licensing revenue? So we kind of have this romantic view, in the States at least, of sole inventors inventing something in their garage and then that invention or that patent to some huge company and making all this money on it. And the fact of the matter is that really doesn't happen very much anymore. In the United States, there are about 3,000 patents that issue every week. And about 2 million patents are enforceable at any one time, meaning that somebody could be sued for patent infringement of any of 2 million patents at any one time. And so large companies just don't have the manpower to go through every one of the 3,000 patents that issue every week and decide which ones are actually relevant to them, which ones they actually want to license. The liability is too great and the manpower is too great to go through all of those. So they don't bother. So if you want to license your technology, then you actually have to seek out that company once you get a patent and beg them and negotiate with them and talk to their accounting and their legal department, their engineers, maybe a VP, some managers, and actually convince them to take on your patent, license it from you, and make this technology. That could take years. It's a full-time job. You may as well just start a company. It'd be much more effective. And in fact, most companies, big companies, this is the path they want to take. They want to watch a startup prove that there's a market, build these connections, build a product, get clients, and and maybe even become profitable. And then that big company will come in and actually acquire that startup. And everybody wins. The founders get a whole bunch of money, and then the big company gets to acquire this team and the technology. Everybody wins, and that's how, and we see this time and time again with our clients. Again, we've have about 100 clients right now, 200 over the last 10 years, and we have one get acquired on a pretty regular basis. But we don't have any of them licensing their technology to another company and generating licensing revenues. So if those are bad reasons to apply for patents, let's go over some good ones. First is to increase leverage over a partner. We have a client who, about a year and a half ago, was getting into a joint licensing agreement with a very big company, a multi-billion-dollar publicly traded company. And that contract stipulated that any intellectual property that came out of this agreement would be shared between these companies, as in they couldn't sue each other for patent infringement. They would own this technology and these inventions equally. But right before our client signed this contract, they came to us, they did a massive information dump, and we brainstormed all the ways that this big company could use our client's technology to improve their own product. We also brainstormed all the different ways that our client and this big company could work together to create new technology. And we wrote about 8 provisional applications on everything that came out of that brainstorm. So right before our client signed this contract, they would have said, everything from now on is co-owned. So before that, we filed these provisional applications. So then the next day, our client goes in and signs a contract, and everything's happy-go-lucky. They're doing great work. They're innovating on a regular basis. And then the end of this contract comes around a couple months later. And this big company says, all right, startup, we had a great time with you. We developed awesome technology. Now we're going to go spin off our own company, and we're going to pour a whole bunch of money into it. And they're going to be a major competitor to you, but we co-own this technology, so you can't sue them. We're going to give them all the money they need, and we're pretty much going to put you all under. So we'll catch you guys the next time when you start your next company. It was at this time that our client said, actually, hold on a second. We filed all these patent applications before we signed the contract. We actually own the technology. So if you want to use it, you're going to have to come back to the table and negotiate with us, license this from us if you want to, but like we own this. This is ours. And that's exactly what happened. That company, the big company, came back to the table, and our client is still alive and well, still producing, still growing on an annual basis. And so in this case, that patent portfolio leveled the playing field between the big company and the little company, put them all at the same table. Patents can also be useful to deter patent infringement lawsuits. So again, there are 2 million patents that are currently enforceable, and we've had over the last 10 years 200-something clients, and none of them has ever been sued. And it's kind of hard to believe. It's not like they're all working in very specialized fields where there's not a lot of innovation. A lot of them are in very popular spaces. And so you can imagine that there are some instances in which our clients infringe someone else's technology. And at the same time, our clients have strong patent portfolios. And so it's likely that that other company whose patent our client infringes, that company also infringes one of our client's patents. And so they know that if one sues the other's going to countersue, and they're just being embroiled in this long patent lawsuit, $3 to $5 million a piece for 4 to 6 years. It's kind of like the Cold War and Russia and the US here. And they each have nuclear weapons and their fingers on the trigger, but no one actually ever pushes that button because they know that once that one nuke gets lobbed from one side to the other, the other's going to shoot some nukes back, and they just totally annihilate each other. But in this case, not even the lawyers win. Everybody's kind of gone. So it's just like, it's all out war, nobody wins, it's a net loss for everybody. And so our clients aren't being sued, and they're not suing anyone, because it's a no-win game. So in this case, you can use patents to deter this patent infringement lawsuit. And finally, you can use patents to stimulate investment. So in the last couple of years, some massive patent portfolios have been acquired, like Kodak and Nokia and Motorola. And these were patent portfolios of several thousand issued patents, selling for billions of dollars. And if you do the math, you come to the realization that an issued patent, at least in the United States, is worth between $1 million and $1.5 million. And the fact that it may have cost you between $20,000 and $50,000 to actually get that patent means that that's a pretty awesome return on investment. And investors understand that. They see that, say you walk into a meeting with an investor prior to a seed round and you show them that you filed a couple provisional applications, and then you walk into another meeting a year later prior to your seed round or your Series A, and you show that excuse me, that investor that you have, you filed a couple non-provisional patent applications, then a year later you show your VC before that Series B round that you actually had issued patents. Like, they see that you're very serious about your technology, you're taking the right steps to protect it, and they see that there's potential for a huge return on their investment. We've seen with some of our clients who've been acquired, maybe Facebook says, we'll give you $30 million. We'll acquire you and your team and your product. And then our clients will come back and say, well, we actually have all these patent applications pending, and we have this one that's issued. And the figure that comes back might be 32 million or 33 million. And so Facebook and other big companies who are acquiring startups, they're not acquiring just patents. They're acquiring the team and the product, and intellectual property is a small subset of what they're acquiring, but it does increase the valuation of these companies. So let's take a quick look at how bigger companies use patents, and some patent lawsuits that have gotten some interesting coverage over the last couple of years. So last year, Yahoo sued Facebook. Facebook turned around and countersued Yahoo, and I think each company looked at the situation, and Facebook saw that what it's doing could potentially be construed as patent infringement of Yahoo's patents, and then Yahoo looked at what it was doing and thought that, well, maybe what it's doing is potentially patent infringement of Facebook's patents, and so they just settled. It settled within a couple of weeks. So this is one instance of deterring a patent infringement lawsuit with your own patents. Actually, one of the patents that Facebook used to countersue Yahoo, I think it was one of the first patents that Facebook actually filed. It had Zuckerberg's name on it. So even that early stage patent application was relevant here. So they both settled. And Facebook and Yahoo decided to cross-license some patents. They would collaborate on some future projects and cooperate on some current ones. So in a sense, it was kind of a net-net. They may have paid their patent attorneys 50 to 100 grand to start this lawsuit, but it was over quickly. It was over in a couple of weeks. On the other hand, we have Apple and Samsung. So a couple of years ago, Apple sued Samsung for infringement of something like 6 patents. And then naturally, Samsung countersued Apple, and then a judge comes back and says, well, Samsung, it looks like you infringed. Give Apple $1 billion in damages, but the judge didn't find that Apple was infringing on Samsung's patent, so Samsung lost out here. So at this point, Samsung owes Apple $1 billion. But it actually wasn't that big of a sting to Samsung. It's a massive company. They have billions of dollars, not quite as big as Apple, but it wasn't going to put them under. And they could actually pay that $500 million, well, now it's $500 million. The judge 2 or 3 months ago said $1 billion was a little excessive and knocked it down to $500 million, but Samsung could still pay that out of pocket. And for Apple, which, it may have cost them $50 million for that lawsuit. They got the best attorneys in the country, and they're lodging several infringement lawsuits at the same time. Even that $50 million to turn it into $500 million, that's an awesome return on investment in a patent infringement lawsuit. So with that in mind, if you're starting a company, are you actually going to be sued by someone like Apple? Honestly, probably not. It's incredibly unlikely that Apple or Yahoo or Facebook or Samsung or any other big company for that matter is going to sue you for patent infringement. The fact of the matter is that for that big company, it's going to be a couple $1 million to lodge that infringement lawsuit, and then you have to actually pay your attorneys to, to argue in court in front of the judge and the jury to say you don't infringe, and that's another couple $1 million. So at the end of this, say 6 years of this infringement lawsuit, you both have paid $5 million, and the judge is going to say, all right, so you obviously infringe this other company's patent, you have to pay them legal fees on top of some amount of damages. And so just for that company who's suing you to break even, like when you start an infringement lawsuit, you have to have $10 million in capital, like hard cash, tangible product, so that you can actually pay your own side of that infringement lawsuit and the plaintiff's side of that infringement lawsuit. So if you have $10 million in capital, or $10 million in cash to pay both sides of this infringement lawsuit, what are you, like a $50 million company? Maybe a $100 million company? Maybe you're in the medical device space and you just got your product approved by the FDA and you're about to launch and you're actually like a $500 million company because you own the market space because you got FDA approval. And so that's probably years off. Like if you're a startup trying to raise even like a $10 million Series A, it's still unlikely you're going to be sued for patent infringement because it's just not, it's not a win-win, it's not a net positive for someone else trying to sue you. They're not going to get their money back. And so, how about patent trolls? We hear about patent trolls all the time. It's kind of the same thing. Patent trolls have to get their money back from that lawsuit. And they probably have never even heard of you. And they figure that, I mean, even if they have heard of you, they're going to wait until you're really big and you're about to IPO before they sue you. Like Facebook, for example, was not involved in many patent infringement lawsuits of any kind prior to their IPO. But that month before they IPO'd, they were sued twice a day. Just that last month before their IPO, because like there was an officially recognized value on Facebook of like $70 billion. Why would you sue Facebook when they're only worth $1 billion when you can wait until they're worth $70 billion? And so if you have hopes and dreams for being a $70 billion company, expect those patent infringement lawsuits, but it's going to be a couple of years before that happens. So worst case is that another startup sues you. You're vying for the same VC money or the same angel funding. But the chances are this is actually a few years down the road also. It takes 3 to 5 years to get a patent, and so that other that competitor of yours, that other startup in your space, has probably been around for a while. And so if they've been around for a while, you've probably been around for a while, and you may also have patents. You may also have a patent portfolio, excuse me, that you can use to deter this patent infringement lawsuit. So you both have patents that the other company infringes, and so you decide not to wage that war. So let's talk about the differences between how startups and larger companies build patent portfolios. So generally, I think of large companies like a Fortune 500 company having a pretty known trajectory. They effectively know where they're going to be a year from now, maybe even 5 years from now. And they're also slow moving. These big companies, it takes a really long time for them to capture an invention, to actually file that patent application. And they typically will wait to file anything patent related until they have a couple of prototypes in place, or they're about to launch this product to the public. And so in a sense, they just move slowly when it comes to intellectual property. But big companies, they're big. They have a lot of money. And so the one thing that they have going for them is they can afford massive patent portfolios. So we're talking, a multi-billion-dollar company could be spending millions, if not tens of millions of dollars a year on building their patent portfolio. 500 patent applications a year is not unheard of for a big company. And compare that to a startup that's trying to afford 1 patent application a year, it's a pretty big difference. But the one thing that startups have going for them is that they're maneuverable. They can act quickly. You can have an idea in the morning, write a provisional application, I'll talk about those later, write a provisional application that day and file it a couple hours later and get patent protection on the same day you come up with an invention. You can also pivot quickly. So you can test a product, come up with an idea to adjust it, or just pivot. Things just move much more quickly when you're a small team of 2 co-founders and a couple engineers than when you're a Fortune 500 company with 1,000+ employees. And so this is one way I look at the patent strategy of a massive company. They're waiting until they actually have a product in place, whether it's hardware and they've actually manufactured a couple prototypes, or there's software and they have a beta out with some users. They file very specific, very narrow patent applications on exactly what they're doing. They're not branching out, trying to grab all this patentable area. They're just trying to get what they're doing. And so their patent applications claim a pretty small patentable area, but they file a lot of them. So it's like this patent cloud. And the idea is that a competitor could try to maneuver through this cloud, but there are just so many patents that at some point they're going to hit a patent, and they're going to infringe on that patent. Alternatively, startups work a little bit differently. When you're in your first year, you're trying to file one patent application, and the next year you're trying to file two. The year after that, maybe you file 4 or 5. But those patent applications, they have to be broad enough to cover where you might be a year down the road or 5 years down the road. There are a lot of unknowns. You're not really sure what's going to happen or if this thing is going to work exactly the way that you anticipate. And so you have to file and cover a broad area. Our startups are typically filing very broad patent applications and getting issued very broad patents on their technology. And so with just a handful of patents, potentially a startup could cover the same amount of area as dozens or hundreds of patent applications owned and filed by much larger companies. So the strategies are very different. And in a sense, you can imagine that startups and large companies sort of operate in different spheres of intellectual property. Just how they get patents and how they use them are slightly different, or even significantly different. So has anyone here ever heard of a provisional patent application? Awesome. I'm finding that's the case here in Finland. I realize that I sort of live and operate in a bubble. In the Bay Area, Silicon Valley, everybody has filed a patent application or a provisional patent application. It's just this ubiquitous term. So this is actually kind of exciting to teach you all about provisional applications. A provisional application it's just that, it's provisional. It's current right now, but a couple weeks or years down the road, we're going to modify this document. We're going to add some content to it, change its direction slightly. Provisional application includes only a description and figures. So if you have a concept for an invention, go back, pretend like you're 12 years old again, and describe it like you were 12 years old. Like you don't need really complicated pseudocode or dimensions or specific kinds of materials, unless that's actually what's patentable. You don't need all these really minute details to describe your invention. You can describe it broadly. Then get a napkin, turn it over, sketch some drawings on this thing with a pencil, scan it, and file those documents, the description and the figures, with the United States Patent and Trademark Office. You're a startup, you have fewer than 500 employees, so it's $125. And that gets your foot in the door. You file this provisional application on the same day that you came up with the invention, or you schedule a brainstorm every morning for a week and you figure out exactly what, or broadly what you think this invention is and different ways to do it, capture it in a document and file it with the Patent and Trademark Office in the United States. You can do it all electronically. But what's interesting about that is it gets you patent pending for a year. So, and it's recognized throughout the entire world. Just about every patent and trademark office or patent office in the world that you'd probably want to file a patent in will recognize the provisional application. So you can say patent pending, effectively worldwide. But within a year of filing that provisional application, you're going to have to pay a patent attorney to write and file a non-provisional patent application or a full patent application. That full patent application has a description and figures like the provisional, but it also has claims. Claims, there's really an art to claim drafting. The first claim, the first independent claim in any patent application is one sentence long, and it describes as broadly and narrowly as is needed to describe exactly what this invention is. It describes the crux of the invention, how it's different from everything else it's ever been, and it takes into account all of that prior art. And then it's all in one sentence. in my mind, it's kind of impressive, but then I guess that's somewhat egotistical considering what I do. But that non-provisional patent application has to be filed within a year of the provisional application in order to use the priority date of the provisional. So you file this non-provisional application within a year. That's not a year and a day. It's no more than a year of the provisional, and it claims priority to the provisional. And any patent office, so that you could file that provisional application in the US and the non-provisional application anywhere in the world, generally speaking, and the patent office where you filed that non-provisional application will pretend like you filed it on the day that you filed the provisional application. So you get a priority date of a year earlier. Now,
maybe it's just good to emphasize this is available only in the US, not in
Europe. Yes, the provisional application is an American institution. You can only file provisionals in the US, but you can file a non-provisional patent application in Finland, and that can claim priority to the provisional that you filed in the US, and you can get the earlier priority date of the provisional. Also, what's interesting about the provisional is it can be filed in any language. File it in Finnish if you want, file it in Swedish, file it in German or whatever other language you speak that you're comfortable with. When you file the non-provisional application that claims priority to the provisional, you will have to file a translation of the original provisional, but considering that it's 15 grand for a non-provisional application, $1,000 to pay someone to translate your provisional application isn't a huge amount of money.
Tell about this when it comes public. I mean,
yeah. That's another thing that's interesting about a provisional is that when the patent office gets it, when the United States Patent and Trademark Office gets that provisional application, they gotta lock it away. Like nobody can see it, modify it, change it, even know whose name is on it. It's just, it's locked away, nobody knows about it. If you decide within a year of filing that provisional that you don't actually need the technology, you've pivoted, working on something different, it's really not all that relevant anymore, or maybe you don't even have the funds to convert it to a non-provisional application, it disappears. It's like it never existed. The Patent and Trademark Office shreds it. Whether you file it physically in paper, they shred it. You file electronically, they electronically shred it. It's gone, it disappears. But if you decide within the 12 months to file the patent application, the non-provisional patent application, and that claims priority to the provisional, they tack on that provisional to the image file wrapper for the non-provisional patent application. It becomes part of the application as a whole. Even so, it's still unlikely that anyone at the patent office will read the provisional application. The only time that would come into play is if, well, actually, I'll get into that in a minute. As far as the US patent application goes, it's given a very particular serial number. It's unique and it has this form. Typically, right now we're on 13/ some 6-digit number. It's all sequential. Now, within about 6 months if you filed a provisional application and then a non-provisional application a year later, the non-provisional application will publish within 6 months. But generally in the United States, your patent application will publish 18 months from the earliest priority date. So if you use the provisional patent application, then you get 6 months after filing the non-provisional patent application. And at this point, it becomes public. Anyone can see it. The patent office puts your application in their own particular format, and then it goes up on the database. It's searchable. You can see the figures and the description and the claims and every other part of the patent application. So about 18 months, give or take, after filing that non-provisional patent application, you'll get what's called an office action. Someone at the patent office, an examiner, will pick up your case. They'll read your claims, and then they'll go do a search of other patent application, other issued patents that look similar to what you're trying to claim. They may even just get on Google and type in, some certain keywords and find a news article or some blog post that might also be relevant to your what you're trying to claim, and then they will reject your claims. And it might be that they found a reference that was filed somewhere between here and here. And you can remind them at that point, when you get this office action, that you have this priority date of the provisional. And so you can tell the examiner, hey, you can't actually reject my patent application with this other reference because that reference came after my provisional application. And so this office action, this OA1, the first office action, it comes to you in the form of a letter. It's a formal letter that the examiner writes and sends to you through the patent office's electronic system. And it says, I don't think this thing is patentable in light of all these other things I found. So at this point, you pay an attorney to read that office action and either change the claims, so maybe narrow some things in this area that are so similar to the prior art, but broaden it over here because there's not a lot of prior art in this area, and then maybe argue with the examiner whether or not these claims really are patentable, and then he'll file this office action response on your behalf. And so you might get 2 office actions, you might get 3. We've seen some cases, it's very, very rare in our office. We usually average around 2.5 office actions per patent, but you could get all the way up to 8 office actions, sometimes 12 office actions. And that's at $5,000 a piece. But again, we think we can do it in 2 to 3 office actions. But at this point, you've argued with this examiner for so long, and finally you reach some common ground, and the examiner issues what's called a notice of allowance. It says, all right, we've gotten to the point where this claim is narrow enough to avoid the prior art, and the attorney thinks it's broad enough to still be useful, so here's a notice of allowance. You pay what's called an issue fee, and 3 months later this thing issues, it becomes a patent, and it gets a number, a 7-digit number. That could, again, take 3 to 5 years. There's one other type of patent application that's worth mentioning. I'm sure that at least some of you here have heard of it. It's called a PCT. Does that sound familiar? Anybody? Okay, that's okay. PCT is like an international provisional. It includes claims. Our office will, when we write and file a non-provisional US patent application, at the same time we'll file a PCT if foreign rights are important to our clients. So what a PCT does, you file it with the receiving office in the country in which you're a citizen, and they'll hold on to it for 30 months from the priority date. So if you claim priority to the provisional, it's about 18 months from when you filed the PCT. If you just file the PCT, then you have 30 months, but at the end of that 30-month period, you have to decide where to enter. Like, where else in the world will you want patent protection? So say that you're a hardware company and your product will be made in China, and your primary markets are Japan, Australia, Germany, Finland, and the United States. So at the end of these 30 months, you'll send a copy of that copy of the PCT application to each of those countries where you want international patent protection. So China will get a copy, Japan will get a copy, Germany gets a copy, Finland gets a copy, the US gets a copy, and Australia gets a copy. And then you begin patent prosecution in each of those countries separately.
Who in those countries get the copy?
The patent office in each of those countries will get a copy of that PCT.
There are some countries where there is no office action, like France.
Yes, so it's a good time for me to mention that my expertise is really in the United States. We have foreign associates. We have other patent firms in other countries who will prosecute each of these applications domestically. So that's absolutely the case. That does work that way. So the interesting thing about a PCT is that it lets you delay these patent costs. It's kind of like and PCT does also. So as far as PCT goes, again, it's $125. You file it, you get a year to actually develop your product, to test it, see if it's actually still relevant, that there's actually a market there for this product. Again, it's $125. A year later, that's when you pay the $15,000 to your patent attorney to actually convert this to a non-provisional patent application with claims, which that can actually be prosecuted and turned into an issued patent. Provisional on its own can never be turned into an issued patent. Similarly, a PCT application, it gets your foot in the door with the patent office. And it just says, okay, patent rights are important to me, and I expect to to go after some international patent protection. But you get to delay the cost of actually entering each of those countries for 18 months. 18 months is a really long time. In 18 months, you can found a company, raise $500,000 in a seed round, and then a couple $1 million in a Series A if you're working really quickly. Go from a team of 2 to a team of 20. A year and a half is a really long time. And in that time, you can get the amount of funding required to spend $5,000 to $10,000 to enter in each of those foreign countries. So in the case I gave you of having 6 countries in which foreign rights or patent rights will be relevant and important to your company, I mean, that could be anywhere from $30,000 to $60,000. And if you're a startup trying to raise, $100,000 series or seed round, like that 60 grand to pursue patent protection internationally is a huge hit. So a PCT lets you postpone these costs for an extra year and a half, just like the provisional lets you postpone costs of filing a non-provisional for a year.
So how do they work? Is this like a provisional patent application in the other countries? Or aren't you supposed to pay in the other countries' patent offices for something like an application?
Yes. So the provisional application that you file in the US is recognized anywhere. And if you're only interested in patent protection in Finland, you can file the provisional in the United States and then file a Finnish full patent application a year later that claims priority to the provisional, and the Finnish application will get the earlier priority date. And with the PCT, it's the same deal. So if you file provisional and then you file a PCT, let's go through this. So you file a provisional, then you file the PCT application a year later, claiming priority to the provisional. And then 18 months after that, you enter all of these national stage. You enter the PCT, a copy of it, into the national stage in each of these other countries. And the national stage applications in, what did I say, China, Japan, Australia, Finland, Germany, United States, they all actually get the priority date of the provisional application. And so you can effectively postpone, by using a provisional and a PCT, you can postpone the cost of filing domestic national stage applications by a year for a PCT and up to 30 months for a year for provisional, up to 30 months for a PCT. And that time can just be, that can make it or break it for you. Having that extra year to 30 months to raise money could mean the difference between whether or not you can afford to file that patent application or not, whether you can afford to pursue foreign rights or not. So, are there any questions about that? Does that make sense? Okay.
Well, is the PCT filed in each of these countries at the time of PCT?
So the PCT is just filed with the receiving office in one country. And that receiving office will hold on to it for a little while. They may actually look at it, and the issue is sort of an informal office action. You don't have to respond to it. It usually comes 6 months after filing. But effectively, they just hold on to it. And when you're ready, up to those 30 months, you can ask them to send copies to each of the national stage, each patent office in the countries where it's relevant. So it's a one-time fixed cost for a PCT.
So somebody in those countries may actually come about with a similar invention, make an attempt to patent it.
Yep.
And somebody comes with a PCT and says, hold on, I got this first.
Yes, so you can use the provisional, the date of the provisional to overcome all that prior art. So, yeah. Okay, so let's also discuss what you actually get with an issued patent. So you got through these 3 to 5 years of prosecuting your patent application, and it became a patent. What does it mean? What can you actually do with it? We say patents give you exclusive rights. It's not exclusive rights to make and use that invention. It's you have the right to exclude someone else from making and using the invention. There's a difference between patentability and infringement. Patentability, it asks, has anyone else ever done this before? Have they ever combined these nuts and bolts and these sheet metal pieces this way to make this thing, or combine these these steps, these methods together to get this particular output. And if no one else has ever done this before, this thing could potentially be patentable. On the other hand, infringement asks the question, are you doing everything that's claimed in this invention, or claimed in this patent? So you have that first independent claim, it has a series of elements. If you do every one of those elements, so every one of those steps, or you have a product that includes every one of these components, that could potentially be infringement. They're totally separate issues. So it's kind of an interesting example. Gutenberg invents the printing press in around 1450. Changes the world. So all of a sudden we can make books relatively rapidly. It's a huge deal. Let's imagine he gets a patent on the printing press. And then a couple years later, this guy called Frederick Kunig comes around and gets a patent on a steam-powered printing press. So now we can make books even faster. So who can actually make a steam-powered printing press?
No one.
Exactly. And the reason for that is that Gutenberg has a patent on a printing press. So he could, well, at the time it was a manual printing press, he could make manual printing presses. And then Kunig comes around and invents a steam-powered printing press, but he can't actually make a printing press, much less, so he can't add steam power to it. So imagine this is like a fence, and Gutenberg has a key to this big fence, a big circle, like everything in that is printing press. And then Kunig has this, inside of that fence, he has a much smaller fence around the steam-powered printing press. And Kunig has a key to that. So Gutenberg can get through the big fence, but he can't get through the little fence because he doesn't have a key to it. And then Kunig has a key to his own fence, but he can't get to it because Gutenberg's fence is standing in the way. So neither one can actually make this printing press, this steam-powered printing press. So at this point, what do you do? So let's imagine that Gutenberg is this old guy, and he wants to retire. He's going to own the printing press market for a while. He just wants to go to a beach in Florida and retire. And so he goes to Kunig and he says, listen, Kunig, you got an awesome idea for a steam-powered printing press. You should totally make it. Why don't you make them and then just give me a few bucks for every one that you sell? And Kunig's like, awesome. Like, I'm going to be rich, and all I have to do is pay this old guy like, $5 every time I sell one of these things. Like, I'm going to make my fortune. And so Gutenberg licenses his patent to Kunig. Now, let's say that, on the other hand, Kunig is like this bookworm. He's an English guy, an English major or a language major, and all he likes to do is read. But he had this idea for a steam-powered printing press because he wants books to be cheaper and he wants more to be made so we can read more. And so he gets his patent on the steam-powered printing press. So then he goes up to Gutenberg, who owns this printing press market, and he says, Gutenberg, I think you should license my patent because it'll improve your bottom line. It only costs you $10 more for every steam-powered printing press that you make, but you'll be able to sell them for twice the amount. And Gutenberg says, yeah, that's an awesome idea. So I'll make effectively twice as much money making and selling steam-powered printing presses, and I'll just give you $1 for every one I sell. And Kunig's like, this is awesome. So I get money to buy more books, and then books are going to be cheaper and make more of them because there's steam-powered printing presses. Like, everybody wins here. Or say that neither of them actually wants to make steam-powered printing presses. So they license their technology to a third party. Say the Wall Street Journal is getting started and they want to become the biggest newspaper in the world. And so they grab Gutenberg and they say, we want your patent. We're going to make and use printing presses, and we'll give you a penny for every newspaper we sell. And then they go up to Kunig and they say, Kunig, this is an awesome idea. We want to license your patent. We'll give you a penny for every newspaper we sell. And Kunig and Gutenberg say, oh, awesome. Like, I didn't want to make printing presses anyway, so this is just icing on the cake. And so Wall Street Journal makes steam-powered printing presses and uses them to print newspapers by the millions. And then maybe a couple years later, somebody else invents this roller, or this cylindrical barrel printing press that makes printing even faster, and then somebody else invents a way to do multiple colors, and the Wall Street Journal licenses all of these. And so they're the only ones in the world that you can make a steam-powered, multicolor, cylindrical, roller, barrel, whatever you want to call it, printing press. And they're printing awesome newspapers by the millions. And they're paying a penny for every newspaper for all of these patents that they license. So this is actually kind of a silly example. Gutenberg died like 300 years before Kunig was even born. So the patent would have expired if he'd even gotten one. But it does sort of illustrate what you can and can't do with patent.
How common are licensing costs nowadays? If you take a mobile phone, for example.
That's a great question. So anybody want to guess how many patents there are on products and on this phone? So,
Thousands?
your right order of magnitude, it's close to 5,000. There are chips in this thing, touchscreen technology, displays, batteries, just actually manufacturing the case. Apple actually uses a proprietary blend of materials to get this particular stainless steel. It's like it's a special 304 series stainless steel that no one else uses. So there's like 5,000 patents on this thing. And you can bet there are things that are licensed here. I don't have any experience in licensing. Like I said, none of our clients, and the 100 clients that we have currently, are just making money by licensing things. They're also pursuing their technology. Maybe that big company that I gave you an example of earlier that was in that joint venture with one of our clients, there may be a licensing agreement there. But does that answer your question? I really don't. I don't do much in this way of licensing. But,
yeah, but so could it be more common that they just infringe and then take it to the court if it is like in the Samsung case? I think Samsung knew that they were infringing, but they thought that they had their own patents and just. Yeah,
I mean, it typically happens. There are markets like the automotive market. Ford is always infringing GM, and GM is always infringing Mercedes, and Mercedes is always infringing Citroën. I guess did they own Citroën? I guess they can't. Anyway, it doesn't matter. They're always infringing each other, and they really just don't care. It's kind of like this mutually assured destruction. They just know that it's not worth suing each other. There are certain markets, like the cell phone market, that's just so cutthroat. They think they're innovating on such a daily basis, but Apple's been making the same product for like 8 years now. It's really kind of silly, but it's such a cutthroat market that we do see like these patent wars between companies like Samsung and Apple. So in a sense, it's sort of a special case because the market is so strange. We hear about it a lot because like it's kind of near and dear to our hearts. We all have cell phones, we all have smartphones, and it seems like a lot of money that they're throwing around. But generally speaking, it's not as common as you think. So I think it's something like 1 out of every 2,000 patents is actually litigated. It's like, what is that, 0.05%, something like that. It's really not that many. If you think about it, it's actually it's fairly efficient the way that patents work.
One question about this, that this product may infringe existing patent if it contains all the elements of the claim.
Yes. So
does it mean that these clouds of small patents are actually more effective that these big companies are making than these larger patents?
So if it's a very narrow, very specific patent with a very narrow and specific claim, what that means is it's easy to change one thing and avoid infringement. So it's narrow, so all you have to do is change one line of code or change where a particular fastener holds these things together, and you can avoid infringement. But if it's a much broader patent application or a much broader claim, it becomes more difficult to skirt around that claim. It's much harder to avoid infringement because now it's a whole bunch of things that you have to change. And as a result, these broader patent applications, and once they issue into patents, they're much more powerful in claiming the space that you want. They're more useful.
Well, can you clarify the terminology? It's like one patent has a number of claims, maybe dozens. What is this element?
Oh, okay. The first independent claim in any patent application, the first claim is an independent claim. And that's as broad as you can describe your invention. And that independent claim typically have, on average, maybe 4 elements. And if it's a hardware product, let's take a cell phone, for example. It has multiple elements. I won't go through all of them, but just generally, it has a display, it has a case, it has an input field, and a battery, and a cellular wireless.
So they are like enumerated under the claim?
Exactly.
Okay.
So when I say element, I mean this discrete, distinguishable component that's separate from all the other elements in that product. Similarly, if it's a method, like let's take email for example. Email was a really big deal in 1970. It had never been done before. And a patent or claim on email could look something like getting a recipient's address. That's one element. And then getting a subject line, another element. Getting a body of text, that's a third element. Converting all of that body of text to ones and zeros, and then pushing that to the recipient's email client, another step. And converting all those ones and zeros back to legible alphanumeric text is yet another element. And that combination of elements, that's what has to be unique for this to be patentable. No one could have, if anybody else put all these steps together in this particular way before you, then your invention is not patentable. If you're the first one to combine these elements, these steps, or these fasteners and these other physical components in this particular way, then your invention in fact is patentable.
And is the hardest part then to see that if it's non-obvious, the clause about that?
Yeah, so we can get into obvious versus novel. It's not a, if we have time for that, let's get into it. It's a little bit more complicated, and when you're a startup and you're trying to figure out, should I actually file a patent application on this particular concept, it's not necessarily a question that you can or even should ask yourself. It's more of it's something that's in a sense better left to an attorney who understands the law, because there are always interesting and nuanced ways to get around novelty or obviousness rejection.
But are most of the office actions about
yes,
that?
That's exactly what they're about. So the novelty question is, has anybody ever done this exactly before? And so in the United States we call these 102 rejections, it doesn't really matter. But the question is this thing novel? And what you would be, the examiner would reject your claim on novelty by finding another patent application that has all of the elements that you disclose in your claim.
So can you actually just go ahead and infringe all the claims except one where you change one element?
So to infringe, you have to perform all the steps or include all the elements of the first independent claim, or any independent claim. But it's the broadest, the overarching claim that you infringe. And so when a judge asks, is trying to figure out how much damages you have to pay the plaintiff in an infringement case, they'll first ask, do you infringe the independent claim? And if you infringe the independent claim, then you'll pay. And how much you pay may come down to how many of the dependent claims you infringe. So those dependent claims add additional steps, or they add additional details to each element in the independent claim. And so generally, infringement comes down to the independent claim only. As far as obviousness goes, obviousness is, the question there is, are there other patent applications, other inventions that have some of the elements in your independent claim? And would it be obvious for somebody, like a mechanic, to combine these things to get your invention? So that's the difference between novelty and obviousness. It is somewhat nuanced in a sense. Again, we could talk about it in more detail later if that makes sense.
Well, I give a comment here. It is said, especially in Europe, that anything in the US can be patented. They have very low level of novelty compared with Europe. So
I'll actually get into that now. But
okay.
do they need take a time for a 15-minute break. You're going to take that.
Audience, do you need a break? No.
Up to you. Do you want?
Oh, it's really up to you guys, whatever you're comfortable with. If I'm boring you, go get some water and some coffee. Should we take 5? You want to take 5 minutes? No. Keep going? Okay. Good deal. We'll keep going. So Tima is a good segue into what is patentable. In the United States, we recognize that it's a fairly low bar as far as what's patentable. We recognize processes, machines, articles of manufacture, and compositions of matter as patentable subject matter. Let's go back to the Gutenberg printing press example. So the printing press itself, as a machine, is patentable, again, as a machine. But the process of actually making the printing press, making a sand casting pattern, ramming up a sand mold, pouring iron into it, and then once it cools, taking out and machining it, and then assembling a bunch of nuts and bolts and all these castings to make this printing press, that process of manufacture is patentable. Also, cutting a couple sheets of paper, running them through this printing press, applying ink to the typeface, pressing that on the page, blowing the page out, letting it dry, and doing this over and over and over again for different typeface sets. Trimming all these pages, binding them into a volume to create a book. That process is patentable. And that book, as an article of manufacture, is also patentable. The ink and that particular composition of dyes and fluids, that's also patentable. So as far as the printing press goes, there could be dozens, if not hundreds of things that are patentable there in various different fields. So the interesting thing here is processes. And in the United States, we recognize processes as being patentable. It doesn't matter if they occur in hardware, in physical space, or in software, in this sort of digital realm of ones and zeros. I actually don't see the difference between hardware and software. If it's a unique combination of steps that have never been done before, it's patentable. And this does differ somewhat significantly from the way much of the rest of the world views patents and software. I think it's, again, like the email example. In 1970, that was incredibly important. It changed the world. We're still using email 43 years later. And it says something, I think. And that was patentable then as a process, as a method of digital steps.
So is method like synonymous with process?
Yes.
So there's no method patent actually, it's process patent.
Well, when we write that independent claim, we say the method for doing something. That's the terminology that's recognized.
We should think of a process, like
Yes.
steps.
Yeah.
Okay.
Yeah, process and method. So in the United States, we have this 3,000-page book called the NPDP. It's kind of like the Bible for examiners and for patent practitioners. And method and process is used interchangeably throughout those 3,000 pages. So.
Oh, I was just wondering where the human genome
falls. The thing, it's actually a process. The question there is it what you actually do with a particular gene, and how you what's the term I'm looking for? How you extract it, and the process that you're doing to it. That's the question of what's patentable. It's not the gene itself. You cannot in anywhere in the world patent something that occurs in nature. You can't patent blood. You can't patent skin. You can't patent hair. You can't patent dirt. You can't patent. You can actually patent plants, which is interesting. But other than potatoes, you can't patent potatoes. Tubers. I'm not kidding. It's actually the case.
But public media talks about the human genome being patented. Just like
it's a common misnomer. It's a common misconception. It's actually isolate. That's the word I'm looking for. It's like, how do you actually isolate a gene? There's a step or a series of steps required be performed to isolate that gene. There's a machine that's you need to isolate that gene. And those are things that are patentable. So just generally, another way of looking at what's patentable, at least in the United States, is the method of making, the method of using, and the hardware and software in between. One thing to note, so I'll get into this later, but we actually have clients who file patent applications on methods, software in Europe and in China. And we do get issued patents on what's effectively software. But there is a strong hardware element or a strong hardware undertone to some of those methods. So to say that software is wholly not patentable throughout the rest of the world is a bit of a misnomer too. So I'll give you an example of that later. So the next question is, like, what is actually patentable? So this is a pyramid example that we use pretty often. At the base of this pyramid, you can describe your invention in 10 words. It's the broadest you could describe this invention. And at the top of the pyramid is this 10 million word description of the invention. So it'd be really nice to patent these 10 words. And I think, Timo, you said you've done that before, which is pretty impressive.
10 lines.
10 lines.
Close.
So you can patent. It would be nice to be able to patent these 10 words, but it's probably actually not patentable. It's just too broad. But at the top of the pyramid, 10 million lines of code, probably patentable. It's unlikely that anyone has written exactly these 10 million lines of code before. But it wouldn't be useful to patent that because someone just needs to change one line of code to avoid infringing your patent. And so we have useful at one end of the spectrum and patentable on the other. And somewhere in between is something that's both useful and patentable. And that's probably around 150 to 250 words. So it's a good example of this. I have a client who's making an internet-connected coffee brewing machine. It's actually kind of cool. There's a QR code printed on the back of coffee, and you can scan the QR code, and then the machine reads the QR code, and then it pings a server remotely, and it pulls the recipe for that coffee, time and temperature of brewing, and a few other parameters that affect the flavor of the coffee. It pulls all those parameters, loads them into the machine, so when you push the go button, it brews the same cup of coffee perfectly every time. Kind of cool. But it's, very broadly speaking, at the base of this pyramid, it's an internet-connected coffee brewing machine. Like five words, something like that. Useful patent, but not patentable. Again, and imagining this guy in the 1990s, maybe early 1990s, he's really excited about the internet, and he's always forgetting to turn off his coffee machine. And so he patents this internet-connected coffee machine, so when he's at work, he can log into his coffee machine and turn it off. It's possible. Like, it's actually should find it. It would be pretty funny. I can almost guarantee that it's out there. So useful, not patentable. On the other end, you could describe this machine in millions of words. So every nut and bolt, where it's used, and the particular thread it's used, every integrated circuit, resistor, capacitor, the dimensions of the PCB, and the traces and the vias and where they are. Particular materials and surface finishes, and then on top of the physical stuff, all the code that's necessary to run this thing, pinging servers, grabbing all these ones and zeros, and controlling sensors and reading sensors and controlling actuators to brew this coffee. And it really could be 10 million lines of code and CAD models and so on. Useful, not patentable. So we can condense this down to 150 to 250 words. So it's a device with a wireless card, a QR scanner, a heater, and a thermistor, and this base, and and some description of each of these elements. And so you're looking at something around 150 to 250 words that's never been done before. So it's patentable. And he's making, it would also be useful because you described this broadly enough that it would be difficult to make an internet-connected coffee brewing machine that makes a perfect cup of coffee every time differently. And so that 150 to 250 words can be the right balance of patentable and useful. And so if you are interested in patenting your invention, or you think you have an invention that you're just not sure whether or not you should file a patent application on it, do just this. Write one paragraph. It's 150 to 250 words long, and ask yourself at the end of that, does this look like anyone has ever done it before? And then ask yourself, if I actually got a patent on these 150 to 250 words, would this be useful to me? Would it be useful to my company? And if you walk away from that internal conversation thinking that this thing is potentially patentable, because I've never heard of this sort of thing before, and this thing would be useful because I want to build a company around it, it's probably good fodder for your first patent application.
Can I ask about method of use?
Of course.
Does that apply to consumers using the cell phone as a hammer?
That's a fantastic question. So when we write patent applications, we write claims, we ask ourselves who would actually infringe this. And you can write and get patents on methods that an individual would infringe, like claiming using a cell phone as a hammer. And then every time some consumer uses a cell phone as a hammer, you could sue him. But that's a lot of lawsuits, and your consumers are going to hate you because you're constantly suing them. It's just, and how much money are you actually going to get from this guy who's using his cell phone as a hammer? Like, he has $500 less in his bank account because he has to buy a new cell phone. You probably, there's not much of a positive outcome that can come from claiming some process that an individual does.
But it's patentable.
But it is patentable, yeah. I mean, there are patents on picking your nose and brushing your teeth. And patents on like rubbing your stomach in one direction and your head in the other. These are all patentable things. They are essentially protectable, but no one in his or her right mind would sue someone for infringing something like that. You have to sue so many people to even make the lawsuit. Well, I'm not even sure that you could lodge a lawsuit against thousands of people who do this.
But again, like, what would you gain by getting this kind of patents?
Oh, absolutely
nothing. Because the price is quite high.
Absolutely nothing. This is an example of, actually a good example of why we take on clients that we do. Again, all of our clients are actively pursuing their technology. They're actually trying to produce something. They're trying to raise money. That patent portfolio will be useful to them down the road, and they'll continue to use it to raise more money and eventually get more money when they're acquired. Who patent something like picking his nose just doesn't have a better use for his money.
What about these so-called heuristic patents?
Ooh, I don't think I've heard that.
Like Apple has this, how you wipe your hand over in order to...
Gestures.
Yeah.
Yeah.
Picking your nose and other gestures.
So gestures, you can always patent the person's action and applying a gesture to a touchscreen surface. But what Apple and Samsung and other companies in that space, what they're doing is patenting actually capturing that gesture and responding to that gesture. And so like the swipe gesture, you're capturing input at the first position, and then tracking its movement to a second location, and then a release. And in response to that, opening a home screen. At the time, that was really revolutionary and absolutely patentable. Since then, there's been a lot of research into gestures, how to use gestures differently. But that was,
okay, so if you can capture the gesture with a different method, then you can have another patent.
Yep.
Yeah. It appears to be the same, but it's not.
Yeah, like a good example is like a pinch. see if I've got something I can zoom in on. So like you've got a browser open and you want to zoom in on your phone. It's a different gesture. There's 2 points. And then capturing an input at the first point and the second point, and tracking movement of the input on the first point to a third point, and the second point to a fourth point. And then in response to that, expanding the image that's displayed, or contracting the image that's displayed. Those are separate gestures, different than the swipe to unlock gesture. Also patented. And
Well, I mean, the same gesture, the
Oh, the
gesture may be same, but
Well,
the method of capturing it is different.
Potentially.
Yeah.
So, I mean, you could use a capacitive touchscreen, you could use a resistive touchscreen, but you don't actually have to say in the claim with a capacitive touchscreen tracking this gesture. You could just say with the touchscreen tracking this gesture. If you do claim,
it covers all
of them.
it.
If you have a somewhat misinformed patent attorney, he could claim with a capacitive touch sensor, capturing and then put on the first region and tracking it to a second and then release and responding to it in some way. But because we all know about capacitive touchscreens and resistive touchscreens and optical touchscreens, the fact that that particular application discloses and claims with a capacitive touchscreen, it would still be obvious to use a resistive touchscreen or an optical touchscreen. And so even though that claims just the capacitive touchscreen, anyone who in the future wants to claim exactly the same method with an optical touchscreen, it's actually not patentable because it's obvious in light of the prior art. It's obvious because we know about all the other touchscreen technologies. So
You probably can take it somewhere else from that, let's say computer screens and whatever, if you go.
I'm sorry.
I mean, like when you have this kind of gesture on the mobile phone, but if you move it to some other, like let's say coffee machine.
And then it's potentially patentable, depending on what you're doing with the input. It is very specific to. But I can't comment just off the top of my head whether or not that will be patentable. It comes down to what you're actually doing and the particular application of it. So this is actually my last slide. So let's say that you decided you're going to start this company. You found a startup around some concept that you have, and you're trying to raise some money. You have to walk up to your investor and probably want to tell him about the status of your intellectual property. And he's going to want to see that you've taken the right steps to protect your intellectual property, that you filed a provisional patent application, or you filed a non-provisional patent application and or PCT. Again, that's probably the first question he's going to ask, and it's going to be relatively important, if not incredibly important, to say that yes, I'm protecting my technology. We'll talk about more on this topic of building a portfolio on Thursday. The other thing that your investor is going to want to know is, do you actually infringe someone else's patents? We have a lot of clients who come to us for the first time. We've just engaged them, and they say, can you help me with this patent search? I just got on Google and Google Patents, and I typed in all these terms and returned 2,000 results. And it's really hard for me to read all 2,000 of these issued patents to determine if I infringe any of them. Or they'll say, can we pay you guys money to search these 2,000 patents for us because it's just taking up too much of our time. We have other things to do. And we always say, stop. Stop right there. It's a little bit too far. When an investor asks if you infringe anything, what he's really asking is, do you infringe any patents held by your competitors, and your most important competitors in particular? So when you do a patent search, figure out if you infringe someone else's patents. You should only be looking at issued patents, patents that are no longer in prosecution, issued. And you should only be searching patents issued by or assigned to your biggest competitors. And stop right there. You may have a list of 2 competitors, maybe 10 competitors, probably not more than that. You want to limit your patent search to just those competitors and just to issued patents. And this issued patent versus pending application is also a very important distinction. So issued patents, we know exactly what's going on. They've been issued, they won't change. We know exactly what each one of those patents claims. With the pending application, we don't know. Like I said, patent applications, while pending, they go through this review process, these office actions. And with every office action, you or your attorney may amend those claims. So the scope of each claim may change through prosecution. So you narrow in one area, broaden it in another. In the United States, you can actually sometimes change entirely the invention that you're claiming from one office action to another. And so we just don't know what the outcome is going to be with the pending patent application. And so avoid them at all costs. Don't search pending patent applications.
Is it possible though? I thought they were kept in the safe.
So provisional applications are kept in the safe, but non-provisional patent applications, they publish after 18 months of their earliest priority. PCTs will also publish. So they're available for you to search. I highly discourage you from searching them because you have to assume the worst. You have to assume that even though right now this patent application doesn't claim my invention may actually be somewhere in the body of that description or that application. And you have to assume the worst, and you have to tell your investors everything that you find. If you find a patent by a competitor that you infringe, or that you may infringe, you have to tell your investor. If you find a patent application that's not issued yet, but it does disclose your invention or what you all are doing, or what your company is doing, you have to tell your investor. That can be really dangerous. Your investor might say, oh my God, like, I don't know what's going to happen here. You all are going to be sued. I'm getting out of here. I'm not getting you any of my money. I'll go find someone else who doesn't infringe any patents. Now, there is an instance in which you may infringe one of your competitor's patents. In the case that that patent is incredibly broad, you can file what's called a re-exam, or re-examination of that patent. And basically you pay the patent office a lot of money. Like in the United States, it's $16,000 to file for re-exam. And the patent office will look at that patent application again. They'll look at those issued claims. And sometimes you can actually convince them that what they gave your competitor was way too broad. They gave him way too much in light of all the prior art. You can even submit other publications and other issued patents and patent applications that suggest that that claim that was allowed was too broad. And so through re-exam, you can actually narrow or totally eliminate these claims that you would otherwise infringe. So effectively, there's always an out.
And as long as it's not issued, you can always support the patent engineer by providing good articles and the websites and so on. So the patent engineer usually only is reading the patents and maybe some top articles, but not going into the
you're absolutely right.
Cloud of articles.
And that's
very educational also for yourself when you are trying to kill your competitor's application.
Yeah, that is true. A lot of people in the United States don't know that you can do that. It's much more common in Europe to engage a patent engineer who's working on someone else's patent. In the United States, you can do the same thing. You can submit prior art to an examiner of a particular patent application in order to invalidate or prevent your competitor from getting a patent. But just generally, if you're trying to raise money, stay away from patent applications. Just focus on patents issued to your competitors and leave it at that. So it's a lot less work for you to do too. That could be an hour of your time instead of a week of your time. So that is actually all that I have for today. Do you have any questions, comments?
There was one question about those. How do you determine your main competitors? Are you looking at also at larger companies or only in your bubble in Silicon Valley?
Typically, our clients they'll know the market space. We're not experts on every company that's out there working on certain technologies, our clients will teach us. They're teaching us the invention, and they're teaching us who the competitors are. And so a startup has probably done some research into the market, probably understands who the key players are. And so sometimes they'll actually ask us to do this search. It's called a freedom to operate search. So they'll tell us their main competitors, and we will get in the patent office website on the database and type in or enter the search bar that searches for the signee by name. And so again, they're providing that list of competitors.
In your experience, how much are the investors on the level with this patent?
So again, I operate in a bubble in Silicon Valley, and being investors, whether you're working on hardware or software, they're very keen on intellectual property. We actually, it's interesting you asked that. So we offer patent advice in addition to just writing patent applications and prosecuting patents. And we typically will say that if you're trying to raise a seed round over $100,000, or maybe between $100,000 and $500,000, you should file at least one provisional application. If you're trying to raise $1 million to $5 million in Series A, you should probably have at least 2 provisional applications and a non-provisional application pending. Investors will want to see that your patent portfolio is growing with your company. Your portfolio is scaling with your company. And we'll get into more details on this on Thursday. And then if you're going into a series, well, as far as Series A goes, if you're trying to raise a Series A of more than $5 million, so maybe you're trying to get $10 million from a couple of VCs, really having issued patents will be incredibly useful in that scenario. Or you have many patent applications pending. So you're walking into that $10 million Series A with 5 or 6 patent applications pending instead of just one.
Could you take this earlier slide?
Which one?
No, the last one.
That was
this one. So you asked, what do the investors want to hear or see? I think something you did not mention, maybe you will come to it on Thursday, but I understood that you don't take customers unless they have investors already kind of assigned to pay the next round of creating the IPRs. And I think this is a great leverage that you give to the entrepreneurs. I mean, you force these investors already kind of give a promise for the next funding.
Yeah, it's the plan was to talk about that more on Thursday, and I'll get into more depth, but just generally speaking, as a startup, you'll probably be raising at least one funding round every year. So Series A 1 year, Series B the next. You may put off, seed round at 1 year, Series A the next. You may actually put off a Series B for 2 years, maybe 3 sometimes if your Series A was big enough. But at least early on, that first year, that first 2 years, we don't like to file those first provisional applications unless there's anticipation that there will be some sort of funding round between that when we file the provisional and when we file the Series A. I'm sorry, I'm mixing that up. Some funding round between when we file the provisional and when we file the full patent application. The reason for that is that provisionals, we charge $5,000 for a provisional application. It's a lot of money, but the full patent application is 15 grand. It's significantly more than the provisional application. And so if you just raise $100,000 in your seed round and you paid $5,000 for a provisional application, is that $100,000 actually going to still be, some of it's still going to be around a year later when you have to pay $15,000 for the full application? And so you raise 100 grand in Series A, and now you just put $20,000 into intellectual property over the course of a year that $100,000 is supposed to support you through. That's pretty difficult. and it's not laying the playing field for some level of success. And so we'd like to see this. We like it when our we highly encourage our clients to file a provisional if and when they intend to raise some new seed or Series A money within the next year. We don't want the provisional and the full application to be on the same funding round. That was a really long ago way of saying that. Sorry. If you follow me through that,
but I have to. It's also a very practical way of keeping the funding coming in reasonable time, because if you have filed these provisional patents at some time, you have only 12 months before you have to apply the real application. And if you put your fundraising somewhere in the middle, then you have about 6 months time to get the money in order to be able to file the patent applications. And it also gives nice pressure to these investors. They know that they cannot just keep pulling you more or better terms, but because they know that if they don't pay the money within a certain time, then the opportunity is gone.
Yeah,
I have seen that happening.
Yeah, what we really don't want is that our clients will spend $5,000 for a provisional application that's really important to their patent portfolio, and then have them abandon that original application because they couldn't afford the non-provisional a year later. That's not a good way to spend money when money's tight. So we'll get into all the ways of all the factors that influence patent strategy, when to file things, when not to file things. We'll get into that on Thursday, but generally speaking, if you have a core patent application in the form of a provisional, you want to be able to convert it to a non-provisional. And funding is a huge factor in when and how to file patent applications.
Okay,